skepticism is, I think, always a good thing when you're dealing with issues regarding search warrants, arrest warrants, and probable cause.
In the Brian Kohberger, Idaho 4 case, Judge Steven Hippler denied all of the defense's motions to suppress and the motion for a Franks hearing in one fell swoop. In this episode, let's take a look.
And taking a look at those documents, we have a special guest to help us figure it out. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the pleasure of being joined by Kevin Curtis.
It's good to see you again. We called on you because, as our regular viewers know, you're a past president of the Washington State Criminal Defense Attorneys Association. And you've also been very instrumental at looking at wrongful convictions, and you've had some success with those. What I wanted to ask you about today was just these 4 court orders that came out of the Ada County District Court, the Ada County Court, with regard to the Brian Kohberger case, and his defense, filed a number, I think 12 or 13 motions to suppress and the Franks hearing, and all of those motions were just squashed with 4 orders at the court. First of all, did that surprise you?
No, I think, as we maybe have discussed on some earlier podcasts, we anticipated suppression motions relating both to cell tower, phone, information, and the method of the IgG, or the genealogy, DNA. So these motions were anticipated, and they did provide some clarity, both as to why we have so many sealed records initially, and as to the defense strategy, and a little more evidence regarding the state's case. But I was not surprised by the court's denial of these motions.
Really? Now, if you had been defending Mr. Kohberger, and I don't want to put you in the spot, but I will. If you had been defending Mr. Kohberger, would you have brought those 12, 13 motions to suppress, or would you have handled it differently?
Well, everyone's going to handle it slightly different, and you're also working with a team of attorneys, so you're not only using your own judgment, but you're relying on the expertise and judgment of other attorneys working on the case as you formulate how you want to attack the state's case, how you review evidence, and what evidence you think may be inadmissible and thus suppressible. I do not fault the defense for bringing some of these motions. I think some of the areas in which they brought the motions were not particularly well chosen, and I think you can read the judge's opinion and see where he thought the arguments really did not have a lot of merit. I thought others of them were ones that needed to be brought in a death penalty case, and I would have brought some of them.
Okay. One issue that I had was not necessarily the probable cause affidavits, but the Exhibit A's that were attached to them. And as the defense pointed out, those Exhibit A's on which probable cause was based were done by a collaboration of a bunch of different law enforcement officers from several officers from the Moscow City Police, officers from the Idaho State Police, and from the FBI. And the exhibits were only signed by one person, whether it was Mr. Mowry or whether it was Brett Payne. I had a problem with that. Is that usual? I always thought an affidavit was a statement of one person. Somebody comes to my office, I interview them, I write an affidavit, they sign it, the notary signs it, that's it. And Ann Taylor brought that up in the Franks motion, and the judge squashed that. Is that normal to have an affidavit with so many different people speaking?
It's not really all that unusual, particularly in broad investigative cases. For example, most of your large federal drug cases involve a task force that's comprised of local, state, and federal law enforcement. So you'll have the local police, you might have the local sheriff's county, officials. You might have the state, in this case, the Idaho State Patrol, might have the FBI, you might have the ATF. Some of these drug investigations, for example, can go 2-3 years. They're running confidential informants. So you have a multitude of law enforcement agencies and numerous law enforcement officers or agents working on the case.
I understand that a lot of people, I mean, I used to be a reporter and I had my sources on the inside, and they'd have the state homicide people come in. They'd have the county people come in. They'd have the local people come in. They had consultants come in. So I understand that part of it, but some of our commenters and I had a couple of questions about that. Now, when they were having the actual hearings on these motions, Brett Payne and Detective Mowry were put on the stand, and they had a lot of wiggle room. Well, I don't remember. I don't know. I don't remember that aspect. That was the FBI guy that did that. So how do you nail these people down on the stand come trial? How do you nail them down if you put Brett Payne on the stand and he doesn't remember that detail, or somebody else was doing that? Then you put them on the stand and they don't know, and they all start pointing fingers around in a circle. So from a practical trial standpoint, it just seems like that'd be a really difficult thing to deal with. Am I right?
You're correct in part, but it's not necessary for a probable cause affidavit that the individual signing it himself either conducted all of the tasks there or knows what the other individual did that gave him the information that he included within the affidavit. On a probable cause affidavit, I have rarely, and I don't think I have ever seen, more than one affiant's signature on the probable cause affidavit. And, the common officer doctrine, the fellow officer doctrine for probable cause purposes, both for affidavits and for seizures or stops on the street, without a warrant, can be based on information provided to you by another officer. Somebody's officer says, hey, listen, I've got a car going down the road at 150 miles an hour. And then another officer sees that same car 5 minutes later and it's driving the speed limit. They still have probable cause to pull that vehicle over based on the other officer's comment. So
right.
How you handle it at trial is different than what you would do in the affidavit. At trial, the officers are going to be limited to some extent as to their direct personal knowledge, and that's how you nail it down, so to speak. Now, if you do that during trial and none of the officers cited can recall where any of the information came from, well, then the officers have a huge credibility problem in front of the jury. And so that's how you deal with it as a defense attorney at trial, but it's much different for a probable cause affidavit.
Right. Okay. So yeah, here's the language from the order by Judge Hippler, where he points out that in issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. As the defendant notes, Exhibit A was a working document and drafted as a group effort among multiple investigative officers working on the homicide investigation. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own, even though it was the product of collective effort and not necessarily limited to the swearing officer's own investigation. In issue 1, defendant challenges this approach, arguing, this is where Ann Taylor comes in, she didn't like that approach, arguing that Exhibit A was treated as a wild card to easily get a warrant. Memo page 9. In issue 2, he challenges alleged misrepresentations in Blaker's Exhibit A. So the defendant has not met his burden under the Franks on issues 1 or 2. First, it is not improper. You just said this. So you're in agreement with Judge Hippler here. In issue 1, I'm just juggling my paperwork around here. Defendant has not met his burden under Franks on issues 1 or 2. First, it is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. Second, defendant has not demonstrated in his proffers any misrepresentation or omissions, much less that they were made intentionally or recklessly and had any effect on probable cause. And here's the law. As you just pointed out to us, it is well settled that statements of law enforcement officers that are based upon the observations of fellow officers participating in the same investigation carry a presumption of reliability. Now, being the skeptic that I am, I have a problem with that. Is my skepticism well placed there, or not to just presume that all the other officers are reliable?
I think, a skepticism is, I think, always a good thing when you're dealing with issues regarding search warrants, arrest warrants, and probable cause, of course. But I think you have to put it in context. When these affidavits are presented in front of a judge, or in this case a magistrate, depending on what your state judicial system is, the officer not only submits the affidavit, but they're available. It used to be in chambers. Now they're, of course, telephonic or electronic documents back and forth. But if the magistrate themselves has questions about what officer provided this information, or are you sure on that, they're there, and they can discuss that matter with the affiant. So if there appears to be something within the search warrant affidavit itself that causes concern on a magistrate, who's supposed to be a neutral, detached person, not part of the prosecution team, they can ask, get clarification, or they can deny the warrant and say, hey, listen, I want a little more information on this. So there is a presumption that when a police officer or an affidavit is presented to the judge, and the judge is aware that there is a task force or a number of different agencies working on the case, there is a presumption and knowledge that the affiant himself does not have direct personal knowledge of actually everything that's in there, but it is based on conversations and information provided by a number of sources within law enforcement agencies.
So as one of our commenters pointed out, and that's why we're doing this episode, is because of our commenters asked so many questions. One of our commenters pointed out that probable cause is a very low standard. I think, if I recall correctly, just some articulable facts. Am I right?
Yes, probable cause is two things. Number one, more than likely that a crime was committed.
Right.
Here, obviously. And number two, in a search warrant, that it is more likely than not, in other words, 50.1%, it is more likely than not that the items to be searched, named in the search warrant, bear evidence of that crime. So it's not a high burden. It's nowhere near proof beyond a reasonable doubt. But it is actually, probable cause is a higher requirement than what it is to get a PRTT, or a pen register trap. But yes, listen, was there evidence of a crime? Yes.
Yes.
Is it likely or more probable than not that evidence of that crime may be found in the place to be searched?
Right.
That's the requirement.
Okay, so so the Idaho law and the U.S. Supreme Court law are pretty much the same, because their citations on the page I'm looking at are both Idaho and United States Supreme Court. And before we leave this issue, observations of fellow officers of the government engaged in a common investigation are plainly a reliable basis for warrant applied for by one of their number. The presumption extends to hearsay information from government officials who, while engaged in investigatory responsibilities, discover evidence of possible criminal activity. So, yeah, it's a pretty low standard. I would like to move to, I was interested in the order. Well, before we go to the arrest warrants in Pennsylvania, were you surprised by I was not surprised by the court's order on the IGG. I think there's been a deep dive into a lot of different issues, but that one didn't surprise me. Did it surprise you?
No, it didn't surprise me. I think, a couple things regarding that issue. And again, I think we might have discussed it prior. is that, technology always moves and advances quicker than case law does. So, as we move into the digital age and we move into forensics and DNA revealing, much more information than it even did 15, 20 years ago, case law, has not caught up to a lot of that. So I think it was appropriate for the defense to challenge the IGG methods. Some of the arguments I thought had more merit than the other, but for even appellate purposes, in the event that there's new information that develops both as to technology and as to the particular case, may be ripe for appeal down the line. But, so that being said, I was not surprised that there were challenges to it, and I was not surprised by the court's decision brushing them off.
Yeah, in a death penalty case, if you're defending, you're going to have to bring any argument you can think of. Is it just that the court felt that the DNA testing was in fact reliable? And also the sub point that a lot of our commenters have said, well, the FBI violated its own rules by delving into these genealogy companies where you and I can go and give them DNA, but we can opt out of allowing law enforcement to look at our sample. And the FBI had always had a policy, apparently, of saying, okay, we won't delve into them if they've opted out. And a lot of our commenters were mad about that and pointed out that the FBI violated their own policy. And as no big fan of the FBI, I said, yeah, they violated their policy. They probably violate the law every day, but that does not reflect back on the issue here. The issue here is, were Brian Kohberger's Fourth Amendment rights violated? That's how I read that. Did you agree with the court on that?
I agree with the court on that, and people may not, as you've indicated, necessarily agree with that, but the fact is, and the law is, that number one, internal policies and guidelines are not law, first of all. And secondly, as you pointed out, a violation of an internal policy or guideline, which in and of itself explicitly states this is not to be viewed as either binding. It's not it doesn't rise to the level of a constitutional violation. Now, there are circumstances where, of course, it could, but in this case, certainly, as you look at the privacy interest analysis by the court and the tests for whether you have a constitutional right to privacy that has been violated by the government, this internal guideline or policy does not rise to a constitutional level in this case. I think the court didn't go into great detail, but had, in fact, the testing been done to move to areas other than identity, you perhaps still have an issue that could rise to constitutional proportions. In this case, because all the evidence suggests it was related to identity only and not a lot of other information DNA could reveal, it fell squarely within case law and it was not a constitutional violation.
So that was the first, I would say, the first line of attack by the defense team. They really wanted to get that IGG suppressed because that's a big issue for them. Had they been able to get rid of that, that would have been a big step for them. The next major thing for the defense was they had this motion to suppress the arrest warrants in Pennsylvania, which could have been damaging to the whole case. So this was Judge Hippler's order on defendants' motions to suppress regarding the arrest warrants in Pennsylvania, also the warrants to the apartment in Washington State, and Idaho's warrant to search the person. But the thing they were really going after here was the arrest in Pennsylvania. We did a previous episode with somebody that we collaborate with who felt that the Pennsylvania warrants really were not proper because they were based on law that said that Mr. Kohberger was what's the word I'm looking for? He was a what's the word I'm looking for? He was a refuge. He was a refuge. He'd violated the law by leaving the precinct in Idaho, and he had fled to Pennsylvania. The judge rejected all the arguments with respect to Mr. Kohberger's the arrest warrants. Law enforcement believed the defendant was potentially destroying evidence from the vehicle that was related to the homicides. Law enforcement was also aware that the defendant possessed a Glock handgun, prompting a concern over officer safety due to defendant's heightened mental state of awareness or threat level of police possibly tracking him. Law enforcement made the decision to shorten the knock and announce when executing warrants. So the question here was, was there really a necessity to break into the house with the flashbangs, break down the front door, break the windows, and do all of that? At approximately, did they really give him a chance to come to the door? At approximately 1:14 a.m., CERT made announcements from a bearcat parked in the driveway of the residence. Immediately following the announcements, CERT immediately, there was no, who can get to the front door immediately? Immediately following the announcements, CERT effectuated a forced entry into the residence. Defendant was arrested without incident in a bedroom. His vehicle was located and secured in the garage. Once apprehended, defendant was handcuffed and placed in a police vehicle. And it goes on. Defendant, he was arrested, informed of his Miranda rights, and an interview subsequently began. Two issues before the court. One, whether law enforcement failed to comply with the knock and announce rule in executing the warrants at 119 Lamston, his parents' house. And that's the issue I want to take a look at. The other issue was whether defendants' post-arrest statements are suppressible as fruit of the poisonous tree and or due to a Miranda violation. So the argument that Ann Taylor made that I kind of bought was, why did they have to do the flashbangs? Why did they have to, forcibly break into the house when apparently, he had been seen running. He had been seen apparently going into a drugstore. He was around. And if you recall, the Long Island serial killer was arrested peacefully. The suspected, I should say, Long Island serial killer was arrested peacefully in the middle of the day, a business day in Manhattan. So I kind of agreed that, and do you think that the flashbang breaking into his parents' house in Pennsylvania was justified?
I have probably the same issues that you have with it. Obviously, the presence of a firearm is an issue when you look at the knock and announce rule and you look at nighttime raids. And in federal law, you need specific permission within the warrant itself to explain to the officer why you want to violate the rule that these generally should not be, that you should not knock and announce and or carry out the raid at nighttime because of the circumstances. Breaking into somebody's home in the middle of the night raises the danger of that person not knowing what's going on and responding in a violent manner. So I would have liked to see more information as to why they believe that was necessary when, as you've indicated, they had more opportunities to simply execute an arrest warrant or a search warrant without doing that. Unfortunately, regardless of those issues or concerns, it really doesn't lead to a suppression of the evidence, particularly in this case. No. So even if there is, quote, a foul, and people aren't going to be happy with that, but we see this, unfortunately, and as a defense attorney, it drives you nuts at times that it's might not have been exactly proper, but it's a no harm, no foul. You can't establish either a constitutional violation or it didn't lead to evidence that otherwise would not have been obtained had they done the arrests in a different fashion. And so there really isn't a remedy for that.
I don't remember if you and I talked about the conflict of laws issue in the past. The defense made a big deal out of, Was it Idaho law? Was it Pennsylvania law? Was it federal law? This court said it doesn't make any difference because they're pretty much the same. I always say that the good stuff's in the footnotes. And in the footnotes here, they compared the Idaho law and the Pennsylvania law. The first footnote, number 10, Idaho. The officer may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the warrant if, after notice of his authority and purpose, he is refused admittance. Well, that didn't happen here. Footnote 11, to make an arrest if the offense is a felony, a private person, if any public offense, a peace officer may break open the door or window of the house in which the person to be arrested is, or in which there is a reasonable ground for believing him to be, after having demanded admittance. And again, they, said they were there and then they immediately went in, but I'll continue reading the statute. After having demanded admittance and explained the purpose for which admittance is denied. Okay, that's the second Idaho law. And footnote 12 is a Pennsylvania rule of criminal procedure. A law enforcement officer executing a search warrant shall, before entry, give or make reasonable effort to give notice of the officer's identity, authority, and purpose to any occupant of the premises specified in the warrant, unless exigent circumstances require the officer's immediate forcible entry. So there's shades of difference there. I recall the judge, when Ann Taylor was making this argument in Ada County, I seem to remember the judge saying, he kind of showed his cards. He said, well, yeah, but if there's a weapon in there, it's a safety issue for the police, or if he's destroying evidence. So I guess that defines exigent circumstances, does it not?
Well, it does, and I think the firearm is a valid concern. The destruction of evidence, I think, is really extremely weak. I mean, I didn't see anything in there that indicated, what they believed to be an imminent destruction of evidence. Obviously, the crime had occurred quite some time ago. He'd been in Pennsylvania for some time. I didn't see anything indicated that, you thought there was suspicious activity, in the trash or garbage. But be that as it may, I mean, we come back to the point that a violation of a procedural rule, which, as you've indicated, that even the Pennsylvania is a criminal rule of evidence. But if you have an arrest and the officer uses excessive force, it doesn't invalidate the arrest. I mean, there may be some other type of violation that you may have a cause of action on, but it doesn't rise to the level of a suppression, in this case, of evidence. So
are you saying that the defense? Are you saying the defense wasted their time with these arguments? Because a lot of our commenters said that, even people that are generally tend to give Brian Kohberger the benefit of the doubt, even they were saying these arguments were a waste of time.
Listen, my opinion is my opinion. I did not think this was a really strong argument. I would not have given it really any chance of success at the trial level, and a minimal to zero chance of success on appeal.
All right. So I guess I don't want to beat it with a dead horse. It's just that in this paragraph, it's undisputed that law enforcement executed an abbreviated knock and announce prior to entry into his parents' house. According to the state, however, compliance was excused by exigent circumstances, as we just said, namely law enforcement's belief defendant was destroying evidence of the crime, and that compliance with knock and announce would have placed the officer's safety in jeopardy. Defendant argues those are not true exigencies. He notes that he was surveilled by law enforcement prior to the execution of the warrant, and there is no evidence he was seen with weapons. I'm not going to read the whole footnote, but in the footnote, he points out that there was surveillance and, he was seen at nighttime. There was some thought that maybe he was running around the neighborhood, but actually in the record of the case, that, wasn't really proven. Before I move on to the next order, which I thought was...
I do have a quick comment on that. This doesn't address the legal issues involved in it, but just an observation. is that, the officers probably increased the risk of something bad or violent or some sort of incident arising out of the method in which they executed the warrant by abbreviating the knock and announce and barging in at night versus doing an arrest in daytime when the individual is out and about and alone. So again, that doesn't address the legal issues, but just from a common sense standpoint, you do.
I agree with that point, and it's something that I hadn't even considered too, that if you're barging into someone's house in the middle of the night, like if they were like he was found in a bedroom, it's just like especially if you weren't anticipating something like that to happen, and theoretically if he did have the gun, if you had a gun and all of a sudden people are bursting into your house in the middle of the night and you don't know what's going on, it was almost like an invitation for I don't want to say like invitation for there to be more conflict, but by doing that, you're increasing the chances of, like you said, something violent happening, and then oops, he got shot. All right, we got the guy. He's gone,
Right.
So the next, go ahead.
Yeah.
Go ahead.
Oh, well, I disagree. I mean, generally what you'll see is this type of this type of execution of a warrant is generally done as it relates to violent gangs, where that there are multiple people in a residence that pose a direct threat to officers based on both possession of weapons, prior conduct, statements as to what they would do if they were trying to be apprehended. So it's, I think it could have been handled differently. That's my opinion, but it doesn't change the admissibility of evidence.
Yeah, it really didn't. The next motion I wanted to take a look at, I thought had some interesting issues in it. And this was the order and the defendant's motions to suppress the warrants for AT&T, Google, the USB drive that had the Brian Kohberger's cell phone downloaded into it, Apple and Amazon. And to kind of abbreviate, the defense was saying that the warrants were incorrect, they were incomplete. And before the court are defendants' motions to suppress the information obtained through the subpoenas and the AT&T, Google, Apple, and USB search warrants. Defendant argues the FBI's issuance of the subpoenas constitutes a warrantless search that violated his privacy interests under the Fourth Amendment and Article 1, Section 17 of the Idaho Constitution. He further argues that the search warrants fail to command a search and or lack of particularity. So that was one of his arguments, that the warrants weren't particular and specific enough. The standard here was the standard of review of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. Now, something that interested me in this motion was something called the third party doctrine, which I'm sure you've run into in the past, and it's way down on page 13. Sometimes the good stuff is hidden. And I guess his argument was, how can this be? Well, the court says the subpoenas don't violate the defendant's Fourth Amendment rights at all. Pursuant to the third party doctrine, a person has no legitimate expectation of privacy, and information he voluntarily turns over to third parties. And they cite a U.S. Supreme Court case. This is true even if the information is revealed on the assumption that it will be used only for limited purposes. U.S. v. Miller. As a result, the government is free to obtain such information from the recipient without triggering Fourth Amendment protections. Now, the Miller case applies to bank records. In this case, goes back, I believe, to 1979. And basically what it says is that the United States Supreme Court applied the third-party doctrine to bank records in investigating tax evasion. The government subpoenaed the defendant's bank records, seeking canceled checks deposit slips and monthly statements. The court rejected the defendant's Fourth Amendment challenge because he could assert neither the ownership nor the possession of these business records of the banks. All well and good. That's fine. I think we all know that, that kind of stuff is fair game. In Smith, though, the United States Supreme Court applied that doctrine to information conveyed to a telephone company, the court holding that the government warrantless use of a pen register was not asserted. So you actually mentioned this earlier, that a pen register is okay. But wait a minute. As Kohberger notes, the third-party doctrine has come under increased scrutiny in the digital age. In U.S. v. Moalen, noting commentators and 2 Supreme Court justices have questioned the continuing viability of the third-party doctrine under current societal realities. And in her concurring opinion, United States versus Jones, Justice Sotomayor noted the doctrine is ill-suited to the digital age. So I'll just stop there and say, well, okay, I guess if I order something from Amazon, I guess I really don't have any reasonable expectation of privacy in that. I guess I'll go along with that doctrine. I guess if I call Laney Law after the episode and say, what'd you think? I guess the fact of the call is okay, but certainly the content is protected. So what do you think about the application of this third-party doctrine now to things like cell tower location information and other, electronic data?
Well, that's a pretty broad question, and you've covered really a number of different issues.
That's my job.
Issues of this very broad. Yeah, a great question. Tough to answer in shorter sound bites, but I'll start with kind of where we started with this, and the third-party doctrine is a little bit different, but it's the same concept as the long-standing concept as to what you do in public and what can be observed by individuals who are in a public spot and have a right to be there is not protected. You don't have a privacy interest in that. So if somebody's, a police officer is walking down the street and can look in your window and see, at the time the example was marijuana growing, which is not illegal now in some states, but it's the plain view doctrine, right?
Right,
If
exactly.
they see something in plain view, it's fair game. The third party doctrine is similar to that. It basically is saying the activities that you engage in the normal course of business, so to speak, are not protected. You don't have a privacy interest in that. You're not trying to hide it. You're voluntarily submitting information and or actions or conduct. And it doesn't, the fact that you're doing shopping in your home doesn't provide it more privacy protection than if you did the same thing in a department store.
Right.
So let's go past the sales and purchase. Let's go to what you clicked on and what you looked at, but you didn't buy. Well, should that be private? And what the government would say is that no, it shouldn't be private, because if we've got a security camera in a department store and they see you pick up a roll of duct tape but then put it back down in the shelf and not buy it, that's not protected, is it?
No,
So
I wouldn't think so.
These are simple. So these are simple examples, and it's a much more complicated issue. But those are the simple examples of the third-party doctrine. Now, the CSLI, the cell site location information has been limited to some extent, and the court is trying to. The Supreme Court of the United States is trying to cross a fine line as to when what is being obtained by the government is so all-inclusive and all-encompassing of your everyday life that it constitutes an invasion of privacy. Right. And again, I think this judge has left the door open, saying, listen, there can be circumstances where we're going to extend it past CSLI, but the facts in this case as to what they sought and how they sought it and how they explained to the magistrate why they sought the information, what the purpose was, and the, quote, temporal limitations on it, were sufficient to survive scrutiny. Again, This is an example where I think it was a motion worth bringing, for appellate issues because the doctrine is going to be expanded. Unfortunately, the Supreme Court of Idaho is probably not going to do it. And with the makeup of the U.S. Supreme Court over the next couple decades, not likely to do great expansion to it. But in the digital age, I think there will be expansion of it. But I think, unfortunately for the defense, and I'm a defense attorney, the court's reasoning as to these particular facts and these particular warrants was the correct legal analysis from a trial court perspective.
Right. I have one more question for you because we have a time constraint over here, but you very articulately, thank you, pointed out that this is an issue that hasn't been totally resolved. And this court points that out. The court noted that although one normally does not have an expectation of privacy in his movement on public streets, I mean, if I go across the street, to buy something, I mean, people are going to see me. But the pervasive tracking of movements revealed by historical CSLI was different because it provides a detailed chronicle of a person's physical presence compiled every day, every moment over several years. And I think I'll later, this goes on. You're right. It's a complicated issue. We're only on page 15 and it goes up to page 36. I think one of the notable quotes the court made in allowing them to get into his cell phone records is that, or actually in one of the other motions to suppress, is criminals don't announce where they're going to be. I think this was allowing them to get into his phone. Criminals don't announce where they're going to be, so you can't totally know exactly what you're looking for in these warrants. Kevin, you've been very much, correct me if I'm wrong, kind of in this case on these particular orders, you've kind of sided with the judge. Were there any of these motions to suppress that you thought maybe should have been allowed?
There was one area, and I highlighted it, and I should be able to jump right to it, where I thought the court was a little bit off on the rationale. But as I recall making that note, I did not believe it was sufficient that it would withstand appellate review.
Really?
But I thought I caught it. And as you've indicated, I'm a defense attorney. I mean, I am not one in which I just, I look at it objectively. And a trial court is bound by case precedent. I mean, even if the trial court had different feelings regarding expansion of that, they're bound by what the Idaho Supreme Court and appellate court decisions, those are binding on him. And if there, is to be a change in probable cause standards or in third-party doctrine, those are not for a trial court to do. Those are for either the appellate court,
exactly.
the Supreme Court.
So this motion at the very bottom. The court just denies everything. They denied the motion to suppress the AT&T first warrant, the pen, trap, and trace, the Apple account, federal grand jury subpoena, the Amazon account, motions to suppress Moscow forensic lab warrant. So that is just, I don't know. I actually predicted that they would all be denied. I predicted that they were all going to be denied, but it's kind of breathtaking when you actually see it. It's just kind of breathtaking when you actually see it.
I agree. It is, and I agree with you, and I think that's what I had indicated earlier, that I, absent other information that we weren't aware of at the time, I did not see these motions having a great chance of success. As it relates to the search warrants for the phone records, the Google records, Amazon, Apple, etc., I think the other thing that you have to look at, and again, this is the confluence of the digital age and case law, is the nature of the crime itself. And that is a very important analysis. A singular isolated incident in which you can, limit in terms of particularity, it wasn't pre-planned, it's not involved in an investigation of months or has the potential in a premeditation to find evidence of planning, those type of things. So if it's a singular incident that's somewhat limited, then these, type of warrants probably, wouldn't have gained muster. But in a case in which there's potential evidence of either pre-planning, probably not a singular random act occurring on that particular day, the court's going to give greater leeway to the police indication that they believe that there may be evidence through connections with other people, telephone calls, text messages, pictures, other documents, cell phone location records. The court is going to give much more leeway in an investigative stage to authorize warrants in this case. So the nature of this crime in itself lent itself to the court, I believe, finding that law enforcement had met their burden in why they wanted this information, why they thought it, from a probable cause standpoint, that there was a reasonable probability that evidence of the crime may be found in those records, in that phone extraction dating back even months prior.
Wow. Okay. Thank you, Kevin. I'd love to talk to you a lot more, but today we're up against a time constraint, and so I apologize. But thank you so much for the time that you gave us. Lainey, do you have any closing thoughts on this one for us today?
No, we appreciate your insight on the topic, and I hope that this helped alleviate some of the viewers' questions and concerns about all of this. And I think it's interesting also hearing from the perspective from a different attorney from Andrew, too, because it's interesting seeing the things that each one of you picks out of it.
Kevin, thanks again. Hope to talk to you again soon.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.